you all for coming this morning. As Neva said, it's a very sort of exciting, complicated, tumultuous time, and what's going on in the United States really seems to be paralleling a lot of what's going on here. In the past, there was a lot of friction between libraries and publishers and other rights holders, but it almost never got to litigation. It was kind of, the publishers, I think, at the end of the day realized that the libraries were their biggest customers, and you know, the customer's always right, at least in America. I don't know if that's true here, but at least in the United States we say the customer's always right. There's also, I think there was a sense that it would be unseemly to be suing libraries and educational institutions, that maybe courts would rule against the publishers and that they would lose. And so there was a lot of threatening letters, a lot of saber rattling, a lot of yelling and screaming, but in the end of the day, very, very few cases actually brought directly against educational institutions or libraries. I mean, really a handful of cases, and even the reported cases weren't against the educational institutions themselves, but were against, let's say, a photocopy center that was very tangentially affiliated with the educational institution, but not against the library or the educational institution itself. Now things have changed, and right now we have 3 cases pending in the United States, again, directly against either the libraries or the educational institutions that host the libraries. And it's, you know, one can speculate, why is this happening? I think there's a variety of factors. You know, conceivably the economic pressure on publishers. Perhaps libraries are being a little more aggressive than they have in the past. Perhaps this is all a function of just the changing environment of the digitization and all of the complications that flow from it. But regardless, we seem to have, at least in the United States, sort of crossed the barrier, crossed the threshold where it's perfectly okay for publishers to sue libraries. That the inhibition that may have existed in the past is gone. I'll talk at the end about whether that's a good thing or a bad thing. I mean, you'd certainly, at first blush, if you're talking from a library perspective as I am, you'd think that that's a bad thing, but it's not necessarily a bad thing, and I'll explain that at the end. So what I plan to do today is talk about the 3 pending cases involving libraries. And I'll probably be focusing a little bit more, talking more about the Authors Guild case, because that's the most recent case that was just filed, and it has the most complexity. But I'll talk about the 2 other cases as well. If during, you know, we'll have plenty of time at the end for questions and answers, but if as I'm going, if you have a question, you know, feel free to raise your hand and ask the question. It's important to, you know, especially if you don't understand what I'm saying, you know, it's important for you to make sure that that I clarify the point at the time. So the first case has to do with the Authors Guild versus HathiTrust. So to understand this, we need to go back to the beginning of the HathiTrust, and I think hopefully afterwards the PowerPoint will be made available, so everyone, you know, the university will make the PowerPoint available to you. So you don't need to write down everything if you don't want to. The HathiTrust litigation is actually an outgrowth of the Google litigation, which, as Neva mentioned, there was actually a little spin-off here in Israel, but sort of the big Google case that's been going on in the United States for the past 6 or 7 years. So just to refresh your recollections, the Google Library project was announced back in December 2004. It's hard to imagine it's already been such a long time. So that's already 7 years. The Under the project, Google would entered into a partnership arrangement with several university libraries, most prominently University of Michigan. That was the first university library that they entered into an agreement with, and under the agreement they were basically scanning the books in the University of Michigan collection as well as in the collection of other libraries, both in copyright books as well as public domain books, scanning the whole books from beginning to end. And then, but what Google would do would display snippets. So if you do a search query, what you'd get back would be 3 snippets per work. Snippets meaning just a few sentences, so that you would be able to see, is this book relevant? Does this book have the information you might want? But if you really wanted to get the full context and to really understand what was being said, you'd have to find a copy of the book. You'd have to either go to the library, perhaps buy the book. So it was very much a search tool. It was a way to find the information, or to locate where the information was, but you really couldn't use it directly from the library project. The Authors Guild, which represents about 10,000 authors in the United States, as well as a group of publishers, filed separate suits against Google in October 2005 over this scan and snippet display approach. Google defended their scanning of this huge amount of material under a fair use theory. Right away after the litigation was filed, settlement discussions began. And they continued for 3 years. And no one really knew what was being discussed. What were the contours of the settlement? Everyone sort of assumed, well, because it was scan and snippet display, that's what Google was doing, then the settlement would have to do with the scanning and the displaying of the snippets of these little portions. The settlement was announced in October 2008, and the settlement that was announced really took everyone by surprise, because even though what Google was doing was originally the scan and snippet display, the settlement was this very broad, sweeping commercial arrangement, in essence, where Google would provide all these different services with respect to these books. It would either provide what was called a preview, which was sort of like the snippet display, but much more. So instead of seeing 3 snippets with just a few sentences, instead you would see several pages, and ultimately up to 20%, as much as 20% of any given book. The second product that you'd be able to get would be consumer purchase. A consumer would be able to buy online access to the full text of the book. And the third option would be an institution like, if it was here, the university, but this would only apply in the United States. So university would be able to get an institutional subscription under which they'd be able to get access from the students and faculty at that institution would be able to get access to the entire corpus. We're talking about millions and millions of books. So it was a fabulous research tool it would be a fabulous research tool for faculty and students. The settlement was very, very controversial. It was attacked for many reasons, and we don't need to go into them there because it's really not relevant. We can get into the question and answer period if you want to, but that's not really relevant as to all the controversy. The bottom line is that again, 3 years later almost, the judge rejected the settlement because this was styled as a class action. It was an action on behalf of all the authors and all the publishers whose books were being scanned by Google. The settlement needed to be approved by a judge. That's how our federal rules of procedure work. And the judge in just this past March rejected the settlement. Now again, like everything else in this case, different people read the rejection in different ways and understand what the judge was rejecting and why he rejected it. A lot of it has to do with just that the almost from a procedural point of view, that if you have a case that really deals with scan and snippet display as the original case did, and then you have a settlement that applies to all these commercial, that really offers these commercial products, that's just beyond the scope of what the federal rules allow. That's certainly one way of interpreting what the judge found. In any event, the bottom line is that the judge rejected the settlement. Now, he implied that he might approve a narrower settlement, so a settlement that really would apply just to the scan and snippet display. And the parties are, in fact, still negotiating that narrower settlement. But in the meantime, the litigation has started anew. The judge said, you know, you have to, you know, there's this pending case. We need to litigate this case. And there's actually motions for summary judgment that I think have already been, motions for class certification. Again, it's a procedural issue that have already been filed. A trial date has been set for July 2012. It would basically be a trial on the fair use of the original library project. Now it's possible that there will be a settlement before then, but right now, you know, there's sort of a proceeding on parallel tracks, settlement discussions over here, and litigation on the fair use issue over here, and they're going forward. So you might say, well, what does all this have to do with HathiTrust? So part of the original deal between Google and the University of Michigan and then all of the other libraries was that Google, the libraries would give the books to Google to scan, and then Google would give back to the libraries not only the books that they scanned, but also digital copies of the books. That was in essence like the consideration. That was the payment that the libraries were getting, was digital copies of their collections. And from the library's point of view, that was a pretty good thing to get all of these, to in essence get their the works in their collections digitized without having to pay for the digitization. So they saw that as a pretty good deal from an economic point of view. Under the settlement, there was a resolution of what could be done with these digital copies, because the publishers and the authors were never crazy. I mean, they were upset about Google's copy, right, that Google was making for its database. It was also upset about the libraries getting all these digital copies as well. And so under the settlement, there were restrictions about what the libraries could do with their digital copy. And in essence, the copies would really be almost in a dark archive until they came out of copyright. So the settlement was very restrictive about what any individual library could do with its digital copies that it got back from Google. However, there was one interesting provision of the settlement, and that is that the libraries would be able to, in essence, set up two consortiums or two hosts of the research corpus. And the research corpus was, in essence, this database of all these books. And there could be two places that would have sort of all the books that were scanned by Google. And on those databases, the universities would be able to perform, libraries would be able to perform what was called non-consumptive research. I mean, these are all kind of sort of bizarre terms when you think of, you know, non-consumptive research of books. What does that mean? But it's basically that you wouldn't have people coming in and reading the books. And instead there would be sort of like linguistic analysis, statistical analysis, you know, how words are used, how grammar evolves, that kind of thing. But no one would be reading the books for their content. That was, I guess, seen. Reading a book for its information was a consumptive use, and so this would be, you know, linguistic analysis was seen as consumptive, non-consumptive use. And so the libraries went ahead, in essence, set up the consortium that would operate these hosts, you know, that would host the research corpus. And so the University of Michigan, so the consortium that was set up was called HathiTrust. Hathi is a word in Hindi apparently for elephant. And I guess the notion is that, you know, an elephant never forgets. So that's where this idea of Hathi trust comes from. And so there was, in the two copies, one would be at Michigan and the other would be at the University of Indiana. And you have to understand that while this litigation was going on with Google, Google was scanning books, right? And so by now Google has scanned about 15 million books, and that's in their database. And by now they've already provided Hathi with, you know, so in other words, giving back to the libraries about 12 million books. So that's a lot of books. And so that's the size. So you have the Hathi Trust database has already 12 million books. Now, it's unclear of those 12 million how many are in the public domain and how many are in copyright. As you know, figuring out whether something is in copyright or the public domain is kind of complicated. At least it is very, under US law, it's very complicated. I don't know if it's as complicated under Israeli law. So the estimates are that at least 20% are in the public domain, but that leaves probably 80% that are under copyright. So that's, so we're talking about a lot of books that are in the Hathi Trust database that are under copyright. So the question, so under the settlement, it was very clear what Hathi Trust could do with these books. In other words, it would be the non-consumptive research that I was talking about. But now that the settlement is gone, in essence, what is left? What can Hathi Trust do with these books? Now, I mentioned that there still are negotiations, and so it's conceivable that the negotiations will, if there is a settlement, that they will resolve what can be done with these books, the Hathi Trust books, the scans in their database. But it's also possible that that's just going to be sort of outside the settlement because it's so different from what was originally contemplated in terms of what Google was doing, which was just, again, the scan and snippet display. That's what that litigation was about. And it's important to note that when the Publishers and the Authors Guild sued Google, they did not sue the libraries. So Neva before was talking about contributory infringement. They certainly could have sued the libraries for contributory infringement for giving Google the books for Google to scan, right? That would have been contributing to the infringement, Google's infringement, if in fact that was an infringement. But they never sued the libraries. Again, I think from a political point of view, they felt that that was just not a smart thing to do. But now that suit, you know, it's unclear. There's no settlement in that suit, and it's unclear what's going to be happening with that suit. So there has been, you know, the notion of what do you do about this from the rights holder's perspective. What do you do with this database is a lot more compelling. But meanwhile, the Hathi Trust has been trying to figure out what can it do with these scans. And so it's sort of come up with various projects. Certainly one of the foremost projects is to provide access to the database, to the Hathi Trust database, to people who are print disabled. If they can't read, you know, print disabled, let's say people who are blind or have visual disabilities, they can't read the books, but they can use read aloud functions and other screen readers, things of that sort. So the idea is that to make these copies, these digital copies, usable to that community, to the print disabled community, and that right there would be of enormous value. It would increase tremendously the number and the richness of the collections available, the kinds of works that are available to people with print disabilities. The other thing, of course, would be preservation, that here you'd have 12 million works that are preserved. Now, again, there's a lot of debate about whether the digital copies, these digital scans done by Google are really of preservation quality. But of course, those of you who are familiar with the world of preservation, it's you know, just like you always say, you know, if you have two Jews, you have three opinions. It's the same thing with archivists and people in the preservation field, that, you know, they they have many, many different opinions about what constitutes preservation quality. I think there's a sense that certainly as the Google scans early on in the project, a lot of people feel were probably of relatively low quality, but Google, one of the things that Google does, Google sort of is the whole way Google operates and sort of its search, in the search algorithms, I mean, it's all artificial intelligence, and it's always kind of learning from its mistakes and learning from what it has done before. I mean, that's the way, why the search algorithm is so good. And I think that that's the sense of the preservation as it's gone along. Or the quality of the scans has continuously improved, and so that whereas some of the earlier copies may not have been that good, the more recent copies are much better, and they're actually sort of going back and correcting some of the earlier mistakes, like where you have someone's hand, their hand, the person who was doing the scanning in their hand was photocopied, that kind of thing. I mean, they're eliminating those kinds of mistakes. But also another one of the projects that Google has, or that Hati has looked at, is something with orphan works. And let me tell you a little bit more about what they're thinking about orphan works. So orphan works, as you probably all know, is it's a work that's under copyright, but whose copyright owner is hard to identify or to locate. So again, because you have a copyright term that lasts life plus 70, it might belong to the author, it might belong to the publisher, the author might be dead, it might belong to his children, it might belong to his grandchildren. You don't know who the author's children or grandchildren are. It gets, people who, if any of you have done copyright searches, it's very, very, again, very, very complicated. It's very time consuming. And so a lot of works are sort of in a gray area where you're not sure who is the copyright owner, or if you have a sense of who the copyright owner is, you don't know where he is, right? You don't know where, is he in this country, is he in some other country, hard to locate who the owner is. And so the idea, and of course the orphan works has been a big issue lately. A lot of people have been talking in different countries about how do you solve the orphan works problem. And what Hati proposed to do was first they would have a process for searching for the owner. And if after this process they determined that it was an orphan work, in other words, they couldn't locate the owner or they couldn't identify who the owner was, then they would post a list saying, okay, these are the works that we are proposing to consider as orphan works. And after 60 days or 90 days, of giving people the opportunity to come forward and claim their work and say, no, this work is mine, or I know who the owner of this work is, then the Hati would make that work available, again, full text of that work available, but not to the world. It would only be available to the institution to authorize users of the institution from where that book came, and only the number of simultaneous users as copies in the collection. So again, if University of Michigan Library, if they had a book, they had one copy of a book, after this process had been followed, they would determine, yes, this is an orphan for purposes of the University of Michigan, and then authorized users of the University of Michigan Library would be able to access that book. But if there was only one book in the collection, one hard copy, then only one user at a time at the University of Michigan would be able to access this book digitally. So when you sort of kind of go through the process, it doesn't seem to be all that threatening, and it's not going to lead to, the Napsterization, if you will, of books in the University of Michigan Library. Nonetheless, in September, so just a couple of months ago, the Authors Guild, that's that group of about 8,000 to 10,000 U.S. authors, as well as authors associations in Australia and Quebec, plus 8 individual authors, filed suit against HathiTrust, the University of Michigan, University of California, University of Wisconsin, and Cornell. These are all institutions that are very active at Hathi. And sort of Hathi, for the time being, is pretty much run by the University of Michigan. The complaint has since been amended, and there are other authors associations in other countries. I think some of the Norwegian countries, they have joined this suit. Interestingly, only authors associations, not publishers. The publishers are staying away from this litigation for the time being. And the litigation, even though a lot of people, when the litigation was filed, they were talking about orphan works and how the litigation really was centered on the orphan works project and again making the full text available to students and faculty. If you read the complaint, you see that they're not just focusing on that, they're focusing on the HathiTrust in its entirety. Meaning, you know, from the moment that a library contributes the work to HathiTrust, and then, you know, so then a copy is made in the HathiTrust database, and then another, at least at, you know, at the University of Michigan, and then another copy is sent to the University of Indiana. And then copies are made available. So all those internal copies are the subject of this litigation. And the relief that they're asking for in this case is that the database, this, you know, 12, 15 million works, however many scans are in the collection, that the database be impounded by the court until Congress passes orphan works legislation. Now, the Congress considered orphan works legislation a few years ago. The legislation didn't go anywhere. You know, a relief of that sort, it's kind of a very bizarre idea of relief, given that it's possible that Congress will never pass orphan works legislation, and so to have relief in a litigation case, in a court case, dependent on what Congress does, is a very strange way of mixing things and a very strange way of proceeding. Now, there's many strange things about the case. Perhaps the strangest aspect of the case from a substantive point of view is, again, the original case of what Google was doing, the scan and snippet display, that was all based on fair use. And so that's how the database was built up, by the copies that Google is making in the course of this bigger project. So the way to look at it, the only way to look at it is this a fair use or not? What Google has done in creating this database, and then what the libraries have done in sort of maintaining it and so forth, and what the libraries, what HathiTrust subsequently does with this database. You would think that that's all or largely a matter of fair use. But the Authors Guild claims that fair use is not available because these activities do not fall within the scope of Section 108 of the Copyright Act. And Section 108 of the Copyright Act, that is the specific section that provides a few limited exceptions for libraries. And they say, well, Section 108, that's the library exception. If you don't fall within those exceptions, then you can't rely on fair use. That's the argument that is made in the Authors Guild complaint. What's odd about that argument is that 108 itself specifically says, you know, 108F4 provide, you know, it says, nothing in this section in any way affects the right of fair use as provided by Section 107. It says that in black and white. It says that a library can still rely on fair use notwithstanding 108, so that 108 in no way limits fair use. So it's very odd that they sort of just make this argument that fair use doesn't apply, notwithstanding the very clear provision, very clear savings clause in Section 108. Let me just talk a little bit more about the oddities of this HathiTrust litigation. So I talked about how odd this Section 107, 108 argument is, and I talked about the relief that's a little strange, that you would have that what can be done with this database is contingent on what Congress does in the future. A couple of other things that are strange about the case. First is it's not clear that the parties that are bringing the case actually have standing to bring the case. You have these individual authors, but the individual authors, it's not clear that any of their works are orphaned works, or would be the kinds of works that would be subject to the Orphan Works Project. On the other hand, so anything dealing with the orphan works, these people, these 8 authors, really have no ability, no basis to complain about. But even more profound is these associations. The associations don't own any copyrights, and the notion of an association suing on behalf of its members is at least under U.S. law, is very limited. And so you really probably can't have associations suing and vindicating the copyrights of members. I mean, if a copyright owner has a problem, he should bring the case himself, and it shouldn't be the association that brings the case. The second thing is we have the second thing another thing that's strange about the case is who are the defendants. That they sued HathiTrust, which is again run by the consortium headed up by the University of Michigan. And then all these public universities, University of Michigan, University of California, University of Wisconsin. We have in the United States something called the sovereign immunity doctrine. I don't know if you have anything parallel to that. But under the sovereign immunity doctrine, because we have the federal government, right? And so copyright exists at the federal level. But here you have all these state institutions, and under the sovereign immunity doctrine, which flows from the U.S. Constitution, you can't sue a state entity in federal court unless the state entity agrees to it, okay? Because again, we have this strange notion that the states each have this independent authority. And so courts have held in the past that a person cannot sue a state institution for copyright infringement or for patent infringement. So that's actually a pretty nice situation for state actors such as the University of California and University of Wisconsin to be in, that they get to take advantage of the patent system, and let's say University of California owns lots of patents and biotech and so forth, so they get to sue people for patent infringement, but they cannot be sued themselves for infringement. Now, it's more complicated than that, but that's actually a pretty good arrangement for the universities. In any event, still, it's the sovereign immunity, the institutions here that are being sued all have sovereign immunity, except perhaps for Cornell. Cornell is a quasi-public-private institution. Parts of Cornell are actually owned by the state of New York, and so those parts would be able to take care of sovereign immunity, take advantage of sovereign immunity, but the other parts are not, are private, and so they could be sued. And so, Princeton, Harvard, those are all private institutions, so they can be sued for copyright infringement, patent infringement, but state institutions, it becomes much more complicated. So again, that's an oddity that they, in terms of who they sued, they could have focused on the Hathi members that were private institutions as opposed to the ones that are public institutions, which makes the litigation more complicated. So in any event, this case, like I said, just started, just filed this past September. There have been no dispositive motions yet. I don't think the Hathi has even answered the complaint yet, but all that is we should expect shortly. So let me move on to the other 2 cases. They also involve state institutions. So it's both Georgia State University and UCLA. They're both state institutions, so the sovereign immunity issue is still kicking around in those 2 cases too, and really could have a big role in how they get resolved. So, Georgia State. Georgia State is, again, a public institution. It was engaged in electronic reserves, so this is similar to the case that Neva was alluding to involving Shoken. And they were sued by three publishers, Sage, Cambridge University Press, and Oxford University Press, over their electronic reserves policy. Now, again, many strange things about this case. Perhaps the strangest is at least who are two of the plaintiffs, right? Cambridge University Press, Oxford University Press. These are university presses. What are the university presses doing suing another university? That seems unseemly. Now, some people say, well, Cambridge and Oxford presses really aren't university presses. They're really commercial presses. Or you could say, well, they're British presses and they're suing an American university. But still, I think from a systemic point of view, or from looking at the academic enterprise and the academic community, it is a sad day when university presses are suing universities for activity, and it does suggest that there's a level of dysfunctionality somewhere in the system that needs to be resolved, that if you have to have university presses, if university presses sue universities. Another thing that's odd about it is that the electronic reserve policy that the Georgia State initially had at the time the litigation was started was, in fact, a pretty liberal, shall we say, reserve policy, and people were the libraries were putting very large chunks of works of books on reserve, on e-reserve. Not necessarily the whole book, but they were putting very large portions, multiple chapters of books and so forth, and many issues, many articles from the same issue. It was a very, very liberal policy. After the litigation commenced, Georgia State revised its e-reserve policy, and it adopted a policy very similar to the one that Cornell had adopted after the American Association of Publishers had threatened Cornell with litigation over its e-reserve policy. So Cornell actually entered into negotiations with the publishers, came out with a e-reserve policy that the publishers blessed. That was the policy. So Georgia State, once it got sued, said, okay, we know what will work, right? We'll just adopt the same policy that Cornell has, and then we should be free. They did that, but the litigation persists, and to some extent, these publishers are saying that what they're objecting to now is the way that the policy is being implemented. There have been a lot of, the case has had to go through strange contortions, and because of the sovereign immunity issue. I mean, the way ultimately you can still have a case against a state institution for copyright infringement or patent infringement is you don't sue the institution, you instead sue the relevant administrators, but you can only sue them in essence for injunctive relief. In other words, you can't get damages, but you can sue them for injunctive relief. So you have to find the right administrator who's sort of in charge of the program, and you sue him and say, you seek an order that that person no longer engage in that infringing conduct. So it sort of took a while, because originally in the Georgia State case they were suing the university, they were suing the regents, who are these, who are very, very high up, who probably never heard of e-reserves, didn't even know that there were reserves or e-reserves, didn't know what the E was. I mean, you were talking, the regents are typically politicians who have nothing to do with anything. And so, but finally the right level of people are named, and so the injunctive relief is going against them. But still, this case, there has been a trial, and we're just waiting for the judge to issue a decision as to whether whether in its implementation, whether they exceeded fair use or not. I have a feeling part of what the publishers are focusing on, and part of what is really bothering them, is that the way it's set up at Georgia State is that it's up to each professor to make the fair use determination. I think what the publishers would prefer is if the fair use determination would have to be done by the library, that you'd have to, and with a review by a copyright lawyer, meaning you'd have to have a higher level of review than just having an individual professor of biology or of literature who knows nothing about copyright law making a fair use determination. Instead, it would have to be a centralized determination by someone with copyright expertise. The thinking by the publishers is that more than anything else, that would just slow things down, right? If you have to have, I mean, how many copyright lawyers is the Georgia State University going to hire, right? I mean, they're not, and so what they'd need to do, that's probably the thinking, is that this will, more than anything else, just slow the process down, and so reduce dramatically the number of works that are in e-reserves. Even if the copyright lawyer would apply it as generously as the professors, still by having it done by one person in a centralized way as opposed to a decentralized way with all these professors making their own decisions, I think that's what their real objective is. But as I said, that case, it's been to trial, and now we're just waiting for the judge's decision. But it's been a while. The trial ended many months ago, but I don't know here whether there's any pressure on judges to issue decisions after trial. But I guess it's sort of our judges have lifetime tenure, sort of like faculty members, and so they do it when they feel like doing it, and so this judge seems to be in absolutely no hurry to issue a decision. Finally, I'd like to talk a little bit about the UCLA litigation. Here, I actually am representing. I am part of the litigation team representing UCLA. So I have to say the normal disclaimer that these are my own views and not the views of UCLA. So UCLA has engaged in streaming of films to students in classes. So let me back up a little bit. We have in the Copyright Act an exception, Section 121. And Section 121 allows for the performance of a work in the performance or display of a work in a classroom or similar place devoted to instruction. And the idea was sort of thinking back to when we were kids in school. You'd sometimes have a film shown in class. That was the idea, and so that the showing of the film in a class would not infringe the public performance right in the motion picture because of this exception, 110.1. Now, what universities did, and so this is not, obviously, it was first done in film classes, but then done in other kinds of classes where there would be, let's say, a documentary film or some kind of film that would be relevant. It started with people showing the films in class, but then that takes up a lot of classroom time, right? 2 hours if you only meet if you only have, let's say, 5-6 hours a week of a class. If you spend 2 hours seeing a movie, that takes up a lot of class time. So then they would schedule special times, let's say in the evening, or where there would be screenings of the film. And then they started to have media labs, where students would go and just watch the film on individually or even in small groups. And that all was under 110.1, and that was all seen as pretty non-controversial. Even though the basic idea was that the university would buy typically one copy of the film, right? You just get one originally 16 millimeter film, on the big reels, or then you'd get one copy of a VHS tape or one copy of a DVD, and conceivably thousands of students over time could see it as it is shown over and over again at different times. But UCLA felt that that was still inefficient. UCLA, as you know, is a huge institution, and the media center tremendously overburdened by the number of all these students coming in to see it. Also, it turns out that, not surprisingly, given the importance of media to this generation of students, that more and more teachers are using films as part of the instruction, whether it's documentaries of all sorts, or if it's a sociology class or a psychology class, there are all kinds of documentaries you might want your students to see, or if it's a history class, you might want to have a film about a dramatization of the history, and you can talk about, is this accurate, is it not accurate? But I think professors of this generation of students feel that using media of all sorts is absolutely critical to the educational process. And so there's just a lot more use of films in all kinds of classes in the United States, not just in film classes or media classes. So UCLA said, okay, we're going to start allowing students we're going to stream these films to the students. So if you're enrolled in a class, you'd get a password, and then it would be the film could be streamed to the student's computer. It couldn't be forwarded, couldn't be stored, using all kinds of technological measures. But the net effect from an economic point of view is the same. Meaning before you would have one copy that you would show to multiple students. Now you still have, you buy the one copy, multiple students get to see it. It's just done in a way that's much more convenient to the students. Rather than having to go to the media center to see it, they're able to see the film on their computer. And again, these are not, by and large, the kind of film that they would see on their own, right? These are all, again, documentaries, or they're features, but features that are of educational interest. Certainly not the kind of thing that one would really likely engage in file sharing. There was a distributor, Ambrose Entertainment, that owned the U.S. distribution rights to 25 BBC plays. These were BBC productions of Shakespeare plays that had been broadcast over the air in the UK, and then there'd be assigned, let's say, to an English class, or a class about a drama class. And again, UCLA they bought the copies of these DVDs, and then they would stream it to the students. Ambrose Entertainment objected to the streaming. They said, now we offer our own streaming service. We want you to pay more for the streaming service as opposed to streaming it yourself. And UCLA said, yeah, but we understand that that's what you have, but we already bought the DVDs. We bought the DVDs before you offered the streaming service, so we think we're entitled with the DVDs we already own to stream them. Ambrose sued UCLA, and not only Ambrose, but also its trade association, AIM. And so a lot of the same issues that we've seen in the other cases came up. So first you have the sovereign immunity issue, because they sued UCLA and the regents of the University of California system. Also, you have this association that is suing on behalf of its members as opposed to the individual rights holder. You have Ambrose, which owns the distribution rights for the BBC films, but the complaint was talking about all these other members of AIM. The court, so the Ambrose filed this complaint, UCLA filed a motion to dismiss. the court actually granted the motion to dismiss. It dismissed much of the case on sovereign immunity grounds. But the Ambrose was smart enough to at least to name many defendants. So it named the University of California, the regents, the president of UCLA, as well as the librarians in charge of the library, right? The librarians who ran the media center. So the case the court said, well, the case can proceed against those people. But then the court also, on the copyright claim as to those people, the court dismissed as well, because it turns out attached to the complaint, the original complaint that was filed, Ambrose attached one of its catalogs of the various films it offered. And it's not clear why it attached the catalog. But then one of the associates, and this is why, to those of you who are law students in the audience, why it's important to, pay attention to the details. This associate was very thorough, and actually he's now clerking for the U.S. Supreme Court. He was a very thorough lawyer, and he flipped through every page of this catalog. And he discovered on the last page of the catalog that they had submitted, it said, all orders by educational institutions include a public performance license. They just, and by printing those words in the catalog, it in essence said that, who cares about whether it's fair use or not? They by the terms under which the DVDs were acquired, it stated that we had a license. We were able to perform it as much as we wanted. I don't know if anyone at UCLA had actually ever seen that beforehand, but it was very helpful in the litigation. And it's why you have to, paying attention to the details really can make a difference. So the judge dismissed the case, but unfortunately she dismissed it without prejudice for some of the claims. Without prejudice, what that means is if they can find a way to improve the complaint or address some of the problems, they can refile the complaint. And unfortunately, Ambrose has filed a second complaint. As far as we can tell, it's almost identical to the first one. So we hope the judge will now dismiss it with prejudice. In other words, basically saying, this case is over and leave me alone. But we don't know. They filed a second complaint. We filed a second motion to dismiss, and now it's again before it's going to be before the judge. So those are again these three cases that are going on, and as you can see, there's these overlapping themes of associational standing, of sovereign immunity, obviously complicated copyright issues. The one thing that I alluded to at the beginning, as I said, on the one hand, it really seems that this is kind of a watershed, that now people are no longer, publishers, rights holders are no longer inhibited about suing institutions. Even as we saw in the Georgia State case, where university presses are suing educational institutions and libraries for engaging in those functions. And that would seem to be, at least from a library perspective, a very bad thing. But it seems to me there also arguably is a silver lining. And the silver lining is this. And again, this is obviously talking from completely a U.S. perspective. And I have no way of knowing if this would be applicable here. And that is that people are often very anxious about the possibility of being sued, right? You have, and especially librarians who are unfamiliar with the litigation process, they're saying, well, if I do this or I do that, I might get sued. Now, in truth, you usually don't get sued. You first get a letter from the publisher's lawyer, a cease and desist letter, saying, don't do that. And then at that point, it's up to you to whether you stop doing it or not, right? And if you stop doing it, usually that's the end of the case. They leave you alone. If you continue doing it, then again, of course, you might be sued, but you have that decision point. But you have a lot of people who are very afraid even of getting that cease and desist letter. Somehow, oh, you know, that the sky is going to fall if they do something that maybe a rights holder won't like. But certainly, you know, people have gotten used to maybe getting the cease and desist letters, but they're still very afraid of the possibility of being sued, of litigation. Because they recognize, yes, litigation is costly, but again, there's this sense of, oh, you know, that being sued has this terrible, that just bad things are going to happen. And I think what now they've seen is at least these institutions have been sued, you know, and then you get sued, and you know, the institution continues to function the next day. It's not like, you know, the University of UCLA gets sued and then all of a sudden all the classrooms are shut and education grinds to a halt. You know, the litigation process is slow. It's costly, but it's, you know, still in the grand scheme of things of a multi-billion-dollar budget, it's not that costly. And especially because it's, you know, you have some months that it's more costly, some months that it's less costly. And I think one possibility, and even if the worst comes to worst, is you lose, right? And then you don't do that anymore. I think so there is the people's sort of fear of, or perhaps unreasonable fear about the mere prospect of litigation, perhaps has been limited by the fact that they've gotten sued, and even if the institutions have gotten sued, they say that they have been able to continue to function. And other people see that UCLA and Georgia State and Michigan have been sued, and they continue to function. And so other people are saying, well, you know, maybe it's not the, you know, it's not the end of the world to get sued. Maybe it's worth taking a little more risk, because what's the worst that can happen? We get sued, but it's not like, you know, anyone dies, right? It's not like anyone even loses their job. You know, as long as you're careful and thorough and, you know, you have a basis. And again, if you're a state institution, you're not even going to be liable for damages. So I think the one advantage, perhaps, of this litigation is that, on the one hand, you have the publishers who are less inhibited, but on the other hand, maybe it will make librarians less inhibited, that they're aware that, you know, that what, just like U.S. corporations, and in particular, Neva mentioned before Google, and I've talked before about Google, in the United States, certainly, litigation is just part of doing business, right? And I don't know if there's the same attitude here, but it's just part of business. You know, so you get sued. Then life goes on, and it's not the end of the world. And I think that in its own way, that's a little liberating. And so I think that is a possible silver lining that may, an unintended benefit of this litigation, that especially if the universities win, as UCLA seems to at least have won the first round, but even if they don't ultimately, that it's the notion that it's not the end of the world, and that, you know, it should be part of the risk analysis, but it shouldn't be outcome determinative. The possibility of suit by itself should not and you know, cause people to be overly concerned.